All right, we're live. You notice the camera's pointed straight at the screen. Your images do not appear in the video. However, if I call on you and ask you a question, your voices will show up. So don't be shy. Speak loud, because that's the only camera we got going right now. Okay, so two things, and actually there's three components of what we need to prove during a trial. Okay? The first one is called the criminal mind, the mens rea. Okay, the mens rea. The second is the actus rea. So the mind, the criminal mind, the intent. Did this person have the intent to commit this crime? So in other words, it wasn't an accident. They weren't, God, why do they keep sending this? Teams. I love Microsoft. Don't you love Teams? Everybody has to use them? God, I hate Teams. Okay. So the mens rea, okay, the guilty mind. We have to prove intent. How hard is it? Think about this for a minute. To prove what somebody intended to do. Think about that for just a second, especially if you grew up with brothers and sisters. And you know your brother stole your sandwich. My brother loved to steal my food. He was a big guy. You can see that's why I'm the runt of the family. He was hungry. But if I accused him of stealing my sandwich, the sandwich is gone, so I don't have any evidence left. Did he do it by accident? Was it a mistake? He grabbed the wrong lunch bag? Or did he intend to steal my sandwich? He always intended to steal my sandwich, by the way. Okay, but the intent, how do you prove it? Well, that's what the district attorney's office is faced with. They have to prove this person knew what they were going to do and then committed that act. Which leads us to the actus reus, the actual criminal act. The mind, the criminal mind, and then the action itself to carry out that crime. Two elements, independent from one another, right? The criminal mind, the criminal act. Separate from one another, we don't have a crime. Think about it. We don't have a crime. There has to be what's called concurrence. And we're going to get to that slide here in a minute. Concurrence is where those two elements came together. Okay? So right here in the middle, that's where the criminal act, now we can prove it. Because we have the evidence to prove the intent. We have the evidence to prove the act. And now we have the concurrence where they came together. Follow along. Here we go. So actus reus, the act, it has to be voluntary. Remember, under duress. There's a lot of good movies. The only reason I stole that bank, I went in and robbed that bank, was because they were holding my family hostage. Otherwise, I would have never committed that crime. So we really can't hold someone accountable because they acted under duress. Must be voluntary. Must be willingly. They acted on their own behalf, on their own intent. Possession, the ability to exercise control over the property, the objects. They don't have to actually have physical custody of that property. They don't have to be in possession. They have to be in control. So what does that mean? Not in possession, but in control. Anybody want to take a shot at that one? Okay. Think drugs. Think the top kingpin guy. Is he really ever in control of either the money or the drugs? Not if he's any good. Right? He doesn't actually have possession of these things, but he controls the people that do. Maybe he has a key to a storage box somewhere, and that's where the drugs or the transactions take place or where the money's kept. So even though he's not in physical possession, that person still has control. Does that make sense? Yeah, lights going on? Failure to act, the omission part, don't think too much about it, because I don't want to confuse you. So we're just going to skip over failure to act. Just think of an officer that should have done something but didn't. It's called duty, someone that has to have a duty, an obligation to perform a specific action and fail to do so, resulting in an injury or loss of property, things like that. That's the failure to act. Speech. We talked about speech last week when I said the freedom of speech is in the Constitution. Is it absolute? I said, well, yeah, and then I proved that it wasn't absolute. So that's what this is about. The framers used the term speech. The Supreme Court found that they intended to protect all forms of expression, verbal or otherwise. The framers of the Constitution had no idea you guys were going to be using emojis and texting each other. Okay, they couldn't. But yet there's case law in courts that has protected that type of speech. So the Constitution is a very important document. Freedom of speech is not absolute. There's still responsibilities that go with it. And the example I gave, you're in a theater, crowded theater, and you yell, "Bomb!" Everybody out there's a bomb. You make them go hysterical. The crowd gets up and they rush. And on their way out, they trample each other. 2 deaths. And you thought it was a good joke. It's April Fool's. No. Doesn't work. Okay, there's some responsibility. And then criminal negligence. Negligence such nature that it can be punishable as a crime. Remember, we talked about 2 types of processes through the system. One is the criminal court, the other was the civil. This one here, criminal negligence. If a manufacturer, and I love Ford, but I gotta pick on them, they made those Broncos a little too short, wheelbases were too narrow, they tend to roll, tires blow up, and they knew it, but they thought it was cheaper to pay the lawsuits than do a recall, change the whole manufacturing line. That's negligence. Negligence, civilly liable. But if so many cases are reported that the court finds Ford knew about this ahead of time, failed to act, and people lost their lives, now they can elevate it from a civil court into a criminal court and file under criminal negligence. That's just one example. Pintos, I think that, anybody remember? Yeah, a Pinto, Ford actually, it was Ford too, yeah, made a Pinto. Looked like a gremlin. Okay, I'm dating myself, guys, remember I'm old. Okay, so the Pinto. This car, when hit in a certain position, rear-ended, would explode. It would blow up. That went to court, and Ford lost their butts on that one because they knew the placement of that fuel cell was not in the best place. Okay, so that's criminal negligence. Questions about this slide? Yeah, man.
Is the failure to act, is that the same thing as if someone won't call like 911 or something?
Depends. Does that person have a duty to make that call? You gotta think.
Oh, like an accident or something.
Yeah.
Your fault.
Well, is it your responsibility to call 911?
Well,
As
there's the
just
one
a-
where you're supposed to render aid or something.
Is that the Good Samaritan law? Think it all the way
I've heard
through.
some cases where people have gotten in trouble for not, rendering
Did you
aid.
see in a movie or a good show?
No, it's a real case, like I've seen like where someone didn't, I guess render aid or something.
Okay.
Got in trouble.
Remember last week I told you about the way the law works? The main answer. What was the main answer I told you? Remember, this is important. You're gonna hear a lot of, it just depends. It really does depend. I can't possibly foresee every circumstance, so it's called a fact pattern. It just depends. In that case, maybe there was some culpability, but as a rule, no. We have no obligation. You could stand there and watch. I mean, as a human being, you would think there's a moral obligation to help someone in need, but is it a criminal act not to? And that's what we're talking about. Remember, we're elevating this to criminal, not doing what's right or what's wrong. Speaking of right or wrong, worked on so many cases, and not to pick on the DA's office, but I asked the DA, I go, why? Why are you choosing this case to prosecute and not this case? Look at the outcome. And without fail, the DA would say, because I can prove this one. They don't care. And I go, but it's wrong. It didn't happen. I don't care. The facts are there. I know I can prove this. Even if it's not true. We don't care. They literally, I don't know if you heard it, I don't care about the truth. I only care what I can prove. You ever heard anybody say that? Yeah. See, I thought it was just me up in Kings County where I was working. I worked Kings County, Fresno County. I did some work in Georgia for the DA's office. But yeah, when I hear people talk like that, their mind is focused on the criminal law, and they're absolutely right. It's what they can prove. Even though I'm me, I still think I'm more kind-hearted, and I want to think, but is it right? You got to separate the two. Doesn't matter. What can I prove? Constructive possession at any given time, person may not have actual physical custody. That goes back to that drug kingpin I was telling you about. They don't have to have physical custody. We only have to prove the control. Knowingly, willingly, voluntarily participated by giving the orders, directing his soldiers. Yeah, guilty act. Let's talk about the guilty mind for a few minutes. Specific state of mind. 2 forms, and this is really important. Write this down. I will ding you. It's going to pop up on quizzes. General intent, specific intent. I intended, when I pulled this trigger, to shoot and kill this human being. That's what I wanted to do. That was my intent. I'm guilty of that crime. What I didn't think through, my glasses are the size of Coke bottles. I could barely see a wall. This person moved a little bit to the side when I pulled the trigger. I shot the person behind them. Never intended to do that. So am I still guilty of a crime? I think mens rea. My intent was to kill this person, not that person. So am I still guilty? Absolutely. That falls under the general intent. Someone pulling a trigger of a firearm, whether you intend to shoot this person or this person, should know that the outcome of firing a weapon like that at a human being is going to result in significant injury or loss of life. Whether it's this person or this person, we don't care. It's the loss of a human life. Specific and general intent. You guys got it? Because you're going to see it. And then here's the explanations. A scienter. I don't like the term, but just get used to it. Mens rea, specific form, the guilty knowledge. Guilty knowledge. Okay. Guilty knowledge. I know what I'm doing. I know it's wrong. But for whatever reason, I'm going to do it anyway. So, you got general intent, specific intent, scienter. Transferred intent. A defendant's specific intent to cause harm to one person transferred to the victim on whom the harm actually falls. Intended victim must be similar. Transference cannot increase the criminal's liability. I intended to shoot this one, I shot that guy. That's one. There was a case, 2 kids. I don't really like using this, but it is a good case. 2 juveniles. They're juveniles, so they used to walk this trail all the time. On the top of the hill, there was a cliff where there was a big boulder, right? Day after day, they'd push on this boulder, try to get it a rock. What they didn't think about, though, is at the edge of that cliff, it just rolled straight down into a neighborhood. They didn't think it all the way through. One of those days, they ended up getting that boulder to move, and they tipped it over just enough. That boulder started to rock and roll and went right down that hill and knocked out a few houses. Got a lot of property damage, thank God didn't injure anyone. But still, their intent was never to cause that harm to that property. All they wanted to do is move the rock. Remember, these are juveniles. Is there criminal liability here? Yeah, absolutely. They should have known. They should have known. That's called transference. Transferred intent. Even though they didn't knowingly, it's okay. Remember, you only got to prove to that fictitious person in the jury. That fictitious person, he is unbiased, right? Has no opinion over what's going on. only listens to the facts, and then makes a conclusion. So this fictitious person, what would they conclude? Should those children have known? And I'm not talking little kids, I'm talking teenagers. Should they have known if we move this boulder far enough that it's going to fall off this cliff and maybe hurt someone, definitely cause property damage? Think about it. If you're on the jury, what would you think? Well, the jury found him guilty. So, yeah, because they should have known. Transferred, state of mind. Even though it wasn't specific, it was still general. The general intent was stuck again. Model penal code. Gotta love the model penal code. Where does it exist? The model penal code. General scheme outlines 4 state of minds. Model penal code, first of all, you gotta know what it is. We have California penal code. Then we got a lot of federal laws that we gotta follow. Every state has their own form of penal code. But what is the model penal code? It's this document the feds put out that say, if you cover these things like this in your personal state penal code, you'll be okay. A template, if you will. A template. Follow these guidelines, this model, you should be okay. That's all it is. It's just a guide. Most states adopt it, make some edits, and call it their own, because that's the smart thing to do. So when we're talking about the model penal code, we use that term because it applies to all of our states, even Louisiana to a degree. Remember I told you about Louisiana? They follow French law, not English. But they still fall under model penal code. In a court of law, you're going to hear these terms, so you're blue in the face. Purposeful, knowing, reckless, negligent. Those are the elements that you got to have in mens rea. If one of them is missing, what do you think is going to happen? Do we have a case? Maybe not. Remember what I told you, the term we use in law? Well, what is it? Come on, I told you. What is it? It depends, right? Thank you. Really, guys, it always just depends. Depends on that specific case. It's really that fact pattern of the specific case. That's why we study case law so much. So when something else happens later in life, we want something we can go back and fall on and say, well, wait a minute, this is really similar to Ohio versus Hayes. Then you do your homework and you pull out those elements and how they apply, and you write up a case brief. And because they apply here, you know, we should consider it in this case. Makes sense, right? Yeah? Okay, let's bring it home then. You got brothers and sisters, you're the youngest. Well, you let my older sister stay out till 10 when she was a freshman. You're laughing already. Don't people say that? Well, why can't I stay? That's precedent. Your parents already did that, so why can't I have that privilege? It works the same way in law. Well, the court ruled this way, then you should rule this way in this case. Makes sense, right? Purposeful, it breaks it down. Go back, review these slides if you want to know the specifics. Okay, this is posted in your Canvas course show. Negligence is not a state of mind. It falls more into a tort. That's what we file in a civil court. Remember I told you in a civil court, anybody can sue anybody for anything. Wide open. Wide open. That's called a tort. It's not a wide tortuous act, but it's what we do in a civil court. You have to prove negligence, not in a criminal court. Unless you're filing criminal liability cases. Let's see. Motive. Do we need motive to prove somebody guilty of a crime? Think about it. 50-50 shot. Yes, no?
Yes.
Yes. Wrong. This person shot and killed this person. I intended to shoot and kill. The person died. Do we really care why? No, it's not going to change this person. He's still dead. Really, motive? It's great for TV. It really is. Great for TV, great movies. But what was the motive? Why would they lie in wait? And why this specific? It helps them find a suspect. It's great for investigative techniques. But really in a court of law, if we get the motive, great. It will help during sentencing phases, either to mitigate or aggravate, but really for a guilty finding, we don't care. So remember that one. Really don't care. Motive may be a factor in sentencing. And you know, I put it up there. There it is. But as far as the culpability, doesn't really play a role. Strict liability requires no culpable mental. This more again civil court, or if we're talking negligence in a criminal court for a manufacturer. Okay, think of a manufacturer. Curling irons come into play. Corporation makes millions of these curling irons. Half of them are burning people's hairs. Bless you. 10% are shorting out, causing fires. Right? And with all the product in my hair, I got a lot to lose. So it burns my hair off. But I'm not the only one. There's a class action. Ooh, that's a big word, class action. There's several people that have suffered these same losses. Now we're talking strict liability. The court doesn't care who is responsible in this huge corporation. We don't care. The president, is it the guy that pushes the button, the guy that drives the forklift? We really don't care. They're guilty as a whole. That's strict liability. Mens rea, the criminal intent. Strict liability offenses do not require an intent. It just happened. Examples, traffic offenses, speeding. A driver may be listening to music, totally unaware they're doing 60 and a 50. Somebody give you a ticket for a 60 and a 50. They had a boring day, man. That's all they got to do. Statutory rape. That's a good one. I dealt with some cadets in the academy, and they had to disclose this in their personal history statements. That yes, they had a sexual relation with a minor. Ooh, right? They were 18, their girlfriend was 16. They're now married with 3 kids. Is it a crime? Think about it. He's 18, she was 16. They dated, they had sexual relations. They got married when he hit 20, she hit 18. He's 21. She's 19, they have their first child. He's now 24, expecting their 3rd child. Is he still guilty of a crime because of that sexual relation he had when he was 18? Yeah. Do we care? Strict liability. Now it's up to the court and up to the academy staff to decide, what are we going to do with this guy? We kept him, I was going to kick him out. Yeah. Think about it. That's still a crime. Boy, that really makes you think. Some experts maintain strict liability offenses can never be true crimes, and we'll argue that because they require no mental element. There was no intent. They were in love. That's my example. Most strict liability offenses, violations of regulatory statutes, such as statutory rape. Many interpretation rule canons, construction used in criminal cases. A canon, a presumptive of constitutionality. 2 interpretations of a statute are possible, one constitutional, the other not. The statute will. This is only if you're trying to decide an issue. If it's addressed in the Constitution, but it's also a rule or a regulation, we don't care about the rule, we're going to go with the Constitution says. Search and seizure. Gotta have a warrant. You want to search me? They have no probable cause, no reasonable suspicion. Why are they going to search me? They can't. But there's a rule that says entry into these premises automatically authorizes your person to be searched upon request. I've seen signs like that. Can you enforce that rule? It says you can't. Constitution trumps that rule every time. The only thing they can do is ask you to leave. That's usually what happens. You see a lot of this in Silicon Valley. Corporate espionage. You want to make sure you're on the up and up who you are, things like that. So they have a vested interest to make sure whoever they're allowing onto their premises has good intentions. Okay. So that makes sense. But They cannot violate your constitutional rights. Unless, it's the big Trump one, unless you give them permission. Officer stops you, asks you to step out of your vehicle. You mind if I search your vehicle? You can say yes. But you can also say no. We're gonna talk a lot more about this down the road. You can give consent, you can withdraw consent. Then we'll talk about what really happens. Yes, I use smiling, because I did talk about what really happens when an officer asks those questions. Insanity, I'm not gonna take a lot of time, because insanity is crazy. Right? It's crazy. Why'd you do that? Because I'm crazy. Therefore, you cannot hold me accountable for my actions. Because I'm crazy. Is that true?
No.
What did I just tell you? What's the key word here?
It depends.
It depends. Yeah, good shot. It depends. It might. It really might. Most likely no. A lot of people think if this person truly suffers, has mental illness, it was a mental condition that mitigated this crime, that they can go to court, prove that he didn't have mental capacity to commit this. He didn't know what he was doing. Oh, okay, here you go. Have a nice day. And they kick him out of the court. Depends on the crime. No, that doesn't happen. They usually will send him to a mental hospital for treatment until that person can't stand trial, even if it's the rest of their life. 1% of 1% of the cases filed even use an insanity plea. And very few are successful. Most end up in some type of incarceration, but they don't call it. They put them like an outpatient for mental health. But they're still there because of the court. And once that condition is addressed where that person can stand trial, then the trial moves forward. Okay? That's kind of just a big overview of the way the insanity plea works. There's a lot of other things that come into play. Concurrence, remember I told you that's that middle part? Mens rea, actus rea, and the middle part, that's where the district attorney's office works. Right? And so do the feds. Two different court systems, the federal and the state. Let's focus on the state. That's the DA, and then right there in the middle, concurrence. That's all you gotta know about it. A lot of good information here. Just think of it as that diagram, that Venn diagram, two circles. Where they intersect, that's your concurrence. Elements. Crimes have elements. Each element must be proven beyond a reasonable doubt. Not just one. Every single element of that crime must be proven to a jury or a bench trial, be just the judge, beyond a reasonable doubt that the person that was being charged with a crime is guilty. You're up, buddy. Okay. Like I said, this presentation will be in Canvas maybe this afternoon.